This is my great pleasure, now that GDPR final draft has been published, to welcome you on EU Privacy for All. This session 1 will focus on DPIAs, Article 35. The content will merely outline key provisions for people willing to update, and it is summarized. Here are the topics we will focus on this week. And the new numbering of Article 33 in the frame of trialogue negotiations, Article 35 in the final text. Data protection impact assessment are framed in a really clear way. That is to say, there is a need to carry out such an assessment whenever the processing is likely to result in a high risk to the rights and freedoms of natural persons. The controller will have to carry out such an assessment. He will have also to seek the advice of the data protection officer. A DPIA will be mandatory in 3 cases: whenever there is a systematic and extensive evaluation of personal aspects relating to natural persons. DPIAs will also be needed whenever processing on a large scale of special categories of data will take place, or whenever a systematic monitoring of a publicly accessible area on a large scale will be aimed at. The data protection authorities, DPAs, or supervisory authorities will have to establish a list of the kind of processing operations which are subject to the requirement for a DPIA, but also a list of the kind of processing operations for which no data protection impact assessment is required. All this will be done in the frame of the consistency mechanism whenever such lists involve processing activities in several member states or may substantially affect the free movement of personal data within the Union. The DPIA carried out and handed over by the controller will have to contain at least a systematic description of the envisaged processing operations, an assessment of the necessity and proportionality of the operations, an assessment of the risks to the rights and freedoms of data subjects, and the measures envisaged to address those risks. Compliance with approved codes of conduct by both controllers and processors may be taken on board in this assessment. Where appropriate, the controller will have to seek the views of data subjects or their representative. Where processing having a legal basis in the Union or member state law to which the controller is subject, a data protection impact assessment being already carried out, then the new obligations resulting from the first paragraph we reviewed shall not apply unless member states deem it will be necessary to carry out such a new assessment. However, where necessary, the controller shall carry out a review of the DPIA when there is a change of the risk represented by processing operations. A key recital in the GDPR is recital 84. It stresses all the points already reviewed, but also highlights the fact that where a data protection impact assessment indicates that processing operations involve a high risk, which the controller cannot mitigate by appropriate measures, a consultation of the supervisory authority should take place prior to the processing. Recital 89 refers to Directive 95/46 and the general obligation to notify, making really clear that now the focus is not on the notification principle, but having a new obligation of assessment through DPIAs of the high risks incurred by data subjects concerned. Recital 90 on data protection impact assessment obligation, assessing the particular likelihood and severity of the high risks, make also clear that the DPIA will be the best way to identify the measures, safeguards, and mechanisms to put in place. Recital 91 also reminds us about the 3 cases in which DPIAs are needed. It stresses the fact that the processing of personal data should not be considered on a large scale if the processing concerns personal data from patients or clients by an individual physician, other healthcare professional, or lawyer. In such cases, a DPIA should not be mandatory. Additionally, Recital 92 stresses the fact that data protection impact assessment could be broader than a single project, whenever there is a reasonable and economical reason for having one DPIA carried out for several processing operations. It is also made really clear in Recital 94 that whenever a controller considers that the risks cannot be mitigated by reasonable means in terms of available technologies and costs, the supervisory authority should be consulted prior to the start of processing activities. Additionally, the processor should assist the controller where necessary and upon a request. As already mentioned, it is clear that whenever a controller deems that no measure can be taken to mitigate high risks incurred by data subject, it shall come to the DPA with the data protection impact assessment and consult the DPA before putting in place the processing operations. Article 39 also reminds the obligation to get advice from the data protection office. According to Articles 57 and 64 on data protection authorities and the European Data Protection Board, lists will have to be established to guide controllers regarding this new obligation. Currently, there is no obligation to carry out data protection impact assessment in the directive. However, Article 17(1) paragraph 2 regarding risks stress the fact that they should be assessed for security reasons. What should accountable data controllers get prepared for? First, let's remind that processors will merely have the obligation to cooperate and assist controllers whenever required to do so. Controllers will have to carry out data protection impact assessment when a processing is likely to result in a high risk to the rights and freedoms of natural person. That is to say, as stressed in the GDPR, particularly in two cases, when using new technologies or after taking into account the nature, scope, context and purposes of the processing. Controllers will have to seek the advice of the data protection officer in charge, and whenever possible, of data subjects or their representatives. By default, a DPIA will be required in three cases: when carrying out a systematic and extensive evaluation of personal aspects relating to natural persons, to summarize it all, profiling, or processing special categories of data on a large scale, that is to say mainly sensitive data, or for systematic monitoring of a publicly accessible area on a large scale. The assessment finally will have to contain at least a description of the processing, an assessment of the necessity and proportionality of the processing, an assessment of the risks to the rights and freedoms of data subjects, and the measures taken to mitigate those risks. A single assessment may address a set of processing operations when those operations present a similar high risk. Documentation of the DPIAs should be kept and compliance reviewed when there is a change of risks. Finally, data protection authorities will draft lists of processing requiring or not requiring DPIAs. In the case a controller will deem that no measure can be taken to mitigate the risks identified in a DPIA, let's remind that he will have the obligation to consult the DPA. So the question coming in mind is knowing about EDPB, European Data Protection Board templates, the consistency of the implementation of this new obligation EU-wide, and SMEs specific guidance.